Anyway, this will be your panel for this morning. All of you are experienced practitioners and know what the procedure is, but in an abundance of caution, I want to share that with you. Each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, you need to request that from the court after you've introduced yourself and before you begin your oral argument. You may reserve up to 5 minutes of rebuttal time. Obviously, the appellee gets no rebuttal time. If there's more than one party to a side, we ask that you announce to the court how you're going to share your time when you, before you begin your oral argument. If there are any problems, issues, or concerns, you need to see our Chief Deputy Clerk, Miss Angie Dempsey, who's with us here today. Miss Angie, anything before we get started?
No, Your Honor.
All right, you may call the first case, please.
Farm Credit Leasing Services Corporation versus Jeffrey Daniels.
Good morning.
Attorney Daniel Lawson for the appellant. I'm ready when the court's ready for me.
All right, you may step up, and if you would, just introduce yourself from the podium.
Good morning, Your Honors. I'm Attorney Daniel Lofton for the appellant, Jeffrey Daniels. I may have just a second to organize my papers here. As I say, good morning, Your Honors. The appellant, Jeffrey Daniels, presents this court with what I believe are some of the...
Before you get started, you wish to reserve any rebuttal time?
Yeah, thank you for reminding me, Your Honor. Yes, Your Honor, I'd like to reserve 3 minutes, please.
3 minutes, okay. All right, you may proceed.
I believe that this oral argument will be one of the more straightforward that the court's had in a bit. The court's focused primarily with procedural issues on appeal, one being we are concerned with an order of summary judgment in favor of the plaintiff, Farm Credit Leasing. However, the question for this court is more of a procedural issue to the extent that we want the court to consider the deficiencies in that order and determine that it was not in compliance with Rule 5604, which requires that there be specific findings, there be specific grounds for the grant or denial of a motion for summary judgment. The other, Your Honors, is whether or not the defendant, the appellant now, Jeffrey Daniels, was entitled to a continuance, an emergency continuance of the hearing on that summary judgment motion. And I say these are pretty straightforward procedural matters, Your Honors. The one thing, then I'll start with this, I'll start into my main oral argument with this. The thing that is nuanced, and I think the thing that I would like the court to ponder for a moment when considering both of these issues, because of course they overlap, whether or not the trial court abused its discretion when it failed to grant a continuance under Rule 6.02, the court needs to be reminded of what it knows all too well and what everybody is trying to put in the past. It's the fact that that hearing was 5 months into the national pandemic. Okay, the pandemic was, everyone, of course, this is all fresh enough. Everyone remembers it was March 13th when the president announced that the country was in a state of emergency. This was 5 months into that time period. I believe the court can take judicial notice of that. I believe the court can take judicial notice of the fact that A majority of courts were closed for in-person hearings. This concerns an in-person hearing that occurred during that troubled time. And I think that those facts are going to be very important to the cause analysis under Rule 6.02 and the appellant's request for continuance. Now, I wanted to point out, Your Honors, that let me just back up and give some factual background what this case is about, just briefly, and then some of the procedural posture so the court can be reminded of what we're dealing with. My client was a farmer, is a farmer, Jeffrey Daniels, and the appellee, Farm Credit Leasing, was a bank that issued monies to a broker, Mr. Charles Schindler, for the financing of a piece of farm equipment. There's not a dispute that it's relevant that that broker, Charles Schindler, was convicted of wire fraud. Even the appellee mentions in its brief, I believe it's on page 10, Your Honors, and it cites the court can take judicial notice of an external proceeding of this was a federal case in the Northern District of Mississippi. The court can just note that case exists to the extent that, and like I said, even the appellee puts it in its brief on page 10 that these were the circumstances. Just briefly wanted the court to be aware. It concerned that wire fraud transactions covering a lot of equipment. This piece of equipment was affected. The farmer and the bank, both of these parties were victims of that criminal fraudster. Okay, but bank sues farmer for equipment that he did not in fact possess. And I'm not going to belabor the facts, Your Honor. He did possess a piece of equipment.
That who did not possess?
My client, Your Honor, was delivered a piece of farm equipment with a serial number that did not match the lease that is the subject of this appeal.
And how do we know that?
We know, Your Honor, I can only say that I said I wanted to only touch the facts briefly. The only thing I can say that's in the record that the court needs to just be cognizant of is the fact that Farm Credit admits that that wire fraud case affected these cases. The trial court.
Let's go back to my question.
Certainly, Your Honor.
As I understand it, there was a complaint filed. There was an answer filed. The answer was not verified. There was discovery that was taken, I suppose. I'm not real sure about that. At some point in time, a motion for summary judgment, statement of undisputed material facts were filed. There was no response to the statement of undisputed material facts. And as far as I can tell, there is no other evidence in the record, is there?
Your Honor, other than, Your Honor is correct. To answer plainly, Your Honor, no, there's nothing else in the record.
So, going back to your allegation about a different piece of equipment being delivered than what was purported to be delivered, there's no evidence of that, is there?
Your Honor, the evidence
in the record.
The short answer to Your Honor's question is no, not in the factual record. I believe that the court can, and I was really kind of surprised at this. I don't know if this is in my table of authorities, Your Honor, but there is a case, and this concerned a federal wire fraud conviction. It's the Otherson case, in which a criminal conviction pursuant to an indictment becomes a conclusive determination of what happened in that case. Now, I'm going to leave that where it lies, Your Honor, because the court's primary concern today is not with those facts. It's with procedural issues as to whether or not, I have to apologize, Your Honors, I'm going to get a water. The court's primary concerns today are procedural in nature. And the first thing I want the court to think about is whether or not that summary judgment order in favor of Farm Credit Leasing was deficient under Rule 5604, which requires there to be, and I quote, "The trial court shall state the legal grounds upon which the court denies or grants the motion, which shall be included in the order." Okay, it's a dispositive ruling. I think that's a minimum requisite. I want the court to be aware of persuasive authority, not controlling authority, because it's directly on point with what this court has before it. I practice in Mississippi. The federal local rule in Northern District 7B3E says that the failure to file a response on a dispositive motion is not a basis for granting that motion as a dispositive motion.
What's the rule in Tennessee?
Your Honor, I don't know, well, I do know that the local rules in the Western District do not have.
I'm not concerned about the local rules. I'm concerned about the law in the state of Tennessee. What is the law in the state of Tennessee that if a statement of undisputed material facts are filed and there is no response provided to that statement?
Your Honor, the most on-point thing that I've found, to Your Honor's concern, is in Rule 56.03 and also in Rule 56.04. The requirements of the non-moving party are tied to the hearing date. And it says that a time shall be fixed for the hearing date. I think that something that's very important in this case, Your Honor, is that there was not a dialogue on that hearing date in the first instance. There was not a setting order. A dispositive motion I don't think it's required. I think it's it's all but required by the text of the rule that a time fixed, the date for the hearing shall be at a time fixed, and the requirements of the non-movement are based on that hearing date, Your Honor. In this case, there was a unilateral setting of the date on August 4th. Now, I don't think that the court can be, I'm sure this court's had arguments on this, similar issues, but I don't think the court can really understate the importance of the COVID pandemic to what happened here and how the court should rule.
I want to make sure I understand your argument. Are you trying to say there was never a hearing date set in this matter?
Your Honor, I'm saying that there was no order setting a hearing.
That's really not my question. Did you agree to a hearing date?
No, Your Honor.
Was a hearing date set by the court?
A hearing date was set.
By the court?
Correct, Your Honor.
Okay. And did you receive notice of that hearing date?
Formal, or I don't remember the means by which I received it. I did receive a notice. This was at a time, Your Honor, okay, so I believe that answers the court's question. I'm simply making the point, Your Honor, that I think it's relevant that it was not an agreed upon date and that it was not.
The court's order reflects that this was originally set for hearing on summary judgment on June 2nd, and that it was continued, that hearing was continued at your client's request because of a death in the family. Is that not correct?
That's correct. That's correct, Your Honor. That's correct, Judge McBride.
And so when it was initially set, this was also in the heart of the pandemic. That's
correct, Your Honor. This was 3 months after the announcement. This is at the time when Quarantines are in place, courts are closed, and there's no vaccine. And I think that, and this was an in-person hearing. I think that that's, and this would have been.
Was there some request on your client's behalf to have this hearing virtually or to set it off further because of the pandemic?
I made the request, Your Honor, to have the hearing continued on August, the day before, on August 3rd, and I submitted my motion. There was no opposition to it filed. There was no reason given for its opposition. At that point, the motion had been pending for just 4 months, just 4 months' time. So, what I think it's important that there was no.
If we could be clear about this continuance, as I understand it, from reading the order, and Judge McRae was reading that to you, it was at your request, or the defendant's request, that the case was reset from June 2nd. And at that time, with either you being present in court or virtually, there was an agreed date to August 4th. Do we have that right?
I believe Your Honor's overview is accurate.
Okay. And now you're saying, but on August 3rd, you requested a further continuance. Is that right?
That would have been a second continuance, Your Honor. Correct.
Okay.
A second continuance. I think a fourth or a fifth continuance during the quarantines, the pandemic. My law partner is a high-risk person, and I was in reasonable fear that he would die. Okay, I believe 5 continuances would have been, would not have qualified for any kind of bad faith review. This is, we forget, this is the time period.
Hold on just a second.
Yes, Your Honor.
Does he answer your question?
You did.
Any other questions? You've used your time.
Oh, okay. Thank you,
Thank you.
Your Honor.
May it please the court, I'm Hank Shelton of the Memphis Bar. I'm local counsel for Farm Credit Leasing, and I'd like to introduce to the court my colleague Andrew Scavoto of the Missouri and Illinois Bar, who's counsel for FCL all over the country and who is admitted pro hac on this case and would ask that the court hear him in my place to argue this motion.
All right, thank you.
Thank you, Hank, and good morning. May it please the court, my name is Andrew Scavato from the Stinson Law Firm, representing the appellee, Farm Credit Leasing. This is a very straightforward case for a breach of a lease agreement.
Mr. Gravato, is
Yeah.
this a finance lease? Is that what this is?
It's an, yeah.
So, I mean,
equipment lease, farm equipment.
Basically, the lessee in this circumstance has almost zero defense to payment. Is that correct?
That's correct.
Okay.
And here we have no record of any defense asserted, including fraud. I mean, the only reference to fraud in the record is this vague statement that Your Honor referenced in the affirmative defenses that essentially says, I never received the equipment. But we know he did receive the equipment because he signed a delivery and acceptance certificate, and it was repossessed. I mean, it's a suit to recover on a deficiency judgment after a repossession. So the equipment was received, and the equipment dealer in this case, Mr. Schindler, was indicted. He did go to jail, but there's nothing in the record that would suggest that there's anything about Mr. Schindler's circumstances in criminal court that impacted this transaction or that there's any valid defenses to this lease agreement.
Did the defendant here challenge the proceeds received from the sale of the equipment? Is there a dispute about that at all, counsel?
No, there's no dispute. I mean, this was decided at the summary judgment stage, but it's essentially a default judgment. We've talked about the answer. FCL served discovery, as Your Honor pointed out, including requests for admissions. Those were not responded to, which of course
Which I'm sorry, that was something in the record that I wanted to ask about. I could not see in the record where the court deemed those requests for admission admitted. Did that occur?
Is it, I didn't catch the end of your question, I'm sorry.
Did that occur? Were there were requests for admission made, as I understand it? They're
Yeah.
referenced in the pleadings. But I was unable to ascertain where the court ever entered an order deeming those requests admitted.
I don't think the court entered a unique order on those, but it's incorporated into the order granting the summary judgment motion. It's at page 133 of the record.
And if you've got that in front of you, what does that say about it? Does it say those requests are deemed admitted, or simply that they weren't responded to?
It simply says they weren't responded to. I think there's an inference or an implication, an intent to have them deemed admitted. But in any event, they're deemed admitted, but then we get to the summary judgment stage.
Well, can the court do that, like that? Normally, I see a situation where if someone fails to respond to a request to admit, you have some type of hearing on it, or the court enters an order that deems that those specific requests for admission are made.
Yeah, we did not engage in that particular procedure.
So can the court then, or can we rely upon those requests for admission?
I think so, because it's clear from the record that they weren't responded to, and it forms the basis for part of the court's order. But I also think
I understand
Yeah.
what you're saying, and I'm certainly not attempting to make light of it, but
Right.
there are reasons that requests aren't admitted. There are reasons that you don't do something timely. And I don't know that we can assume those have been admitted.
That's fine. Let's just assume for purposes of the argument that they weren't admitted. I think that, although I do believe the rule requires admitting, denying, or rejecting, it never occurred.
The rules require a lot of stuff that wasn't done.
Consistent with
in this
everything
case.
that's happened in this case, even whether or not they were deemed admitted. And I do want to, we submitted a statement of uncontroverted facts in support of a motion for summary judgment that made our FCL's prima facie case completely and thoroughly, included exhibits, verified documents. The burden shifted to the defendant to respond to those or assert additional facts to establish a genuine dispute. That didn't occur, and the court appropriately granted summary judgment. On review, the failure to respond to a summary judgment, it precludes an adverse party's appeal on a factual basis. This court still conducts a de novo review of whether the judgment as a matter of law was appropriate. Here, again, we're talking about a straightforward breach of lease agreement. There were no defenses, and there's certainly none that are supported by the record.
Let me move to one of the appellant's issues, and that is the trial court's lack of specifying the reason it granted summary judgment. What's your position on that?
A couple of things. First of all, that wasn't briefed, so we didn't brief it in our response brief. I am aware of Rule 56.04 and what it requires. I have read cases on this issue, including several authored by Judge Stafford. First of all, I think the court order complies with 56.04 and is sufficient. Again, this was essentially a default judgment on a very straightforward breach of lease case. The court's order states, mentions that the defendant did not respond to the summary judgment motion, explains that the court reviewed the motion, finds it well taken, explains what the motion's about, includes in here an indication that the court reviewed the affirmative defenses and found them insufficient to avoid summary judgment. Frankly, in this matter, I think the order is sufficient and it complies with Rule 56.04. As I understand case law that you've authored and that follows, I believe it's the Smith versus Lakeside case, which is a Supreme Court case from 2014 that, in my review, seemingly sets the table for, whether or not judgment adequately complies with 56.04. My understanding is that, the policy behind the law that's flown from Smith is that it's not fair for the Court of Appeals to have to do extra work and do the archaeological dig and consider the merits of the case, especially in a complex case.
Don't think it's a question of fairness necessarily, it's just, we don't want to be guessing
Right. And
or
that,
speculating on what the trial court did.
and this isn't that case. And, there's a case that Your Honor authored, it's Huggins versus McGee, it's from 2014, and that's a case where there was a short court order, but Your Honor observed that it was an old case, it was a straightforward case, and this court exercised its discretion to approve the judgment. I think our position is that this judgment is just fine considering the circumstances. 4 or 5 paragraphs explaining that the summary judgment motion was reviewed and accepted by the court. But, I'm not sure what a lengthier judgment would achieve here, or what the trial court would even do differently if it had the
Was
opportunity.
there any theory other than breach of contract under which you were seeking summary judgment?
I think it's just a straightforward breach of lease action. I don't recall, we may have had a throw-in, unjust enrichment or something, I don't recall, but probably not. I could confirm by pulling out my record, but it's a straightforward breach of lease. Another reason, in my understanding, and just stop me if you want me to move on to the motion to continue, but another policy that underlies 56.04 is, I understand courts don't want counsel writing overzealous orders with too much advocacy and then just having them signed off on by a trial court judge, and that's not what happened here either.
Go ahead.
So on the motion to continue, that's a discretionary decision. Trial court has significant discretion. It won't be disturbed unless the record clearly shows an abuse and prejudice to the party seeking the continuance. Trial court abuses its discretion only when it applies an incorrect legal standard or reaches a decision which is against logic or reasoning that causes an injustice to the complaining party. Here, there's nothing in the record that supports an abuse of discretion under that or any standard. Have to provide the party, has to meet a high burden for the motion to continue and supply a strong excuse. We discussed the factors that the Tennessee courts review in our brief. The relevant factors include the length of time that the proceeding has been pending, the reason for the continuance, the diligence of the party seeking the continuance, and the prejudice to the requesting party if the continuance is not granted. Mr. Daniels' brief does not analyze those factors at all. Here we have a summary judgment motion that was not responded to. Statement of uncontroverted facts had essentially been deemed admitted. It had been pending for 4 months, and the deadline for responding had passed at the time of the hearing. It had been continued once already, as the court has observed at Mr. Daniels' request. Everybody was aware of it. Daniels had not pursued any discovery. He had not opposed the motion. He hadn't done anything at that point to suggest that more time was needed for anything other than delaying the outcome. The motion to continue notes that counsel became aware of his partner's COVID diagnosis on or around July 20th, which is a good 2 weeks before the eve of this hearing. Counsel had 14 days to notify FCL of those circumstances and talk about it. Instead, there was an email that went to the court after midnight, essentially on the morning of the hearing, submitting a motion to continue. The motion, it technically wasn't filed until 9/18. The judge clearly had it at the hearing and denied it at the hearing. We never discussed it, never had an opportunity, and counsel didn't appear for the hearing to argue the motion. The motion suggests that counsel needed additional time to prepare a response, but it doesn't explain why a response wasn't submitted on the proper timeline months before, or why an extension wasn't obtained, at the time of the original deadline. On the prejudice inquiry, there was no prejudice. The die was cast here, failure to respond to a statement of facts, failure to oppose a summary judgment motion. no valid defenses. I don't believe that there's anything that could have happened in another few weeks or a few months that would have changed the outcome. So trial court properly exercised its discretion and granted the motion to continue. So those are essentially the 2 points that Mr. Lofton raised. One was 56.04, which I'm happy to discuss further if you'd like, if the court would like. The second was the motion to continue. And that's our position on both of those points. And just open the floor for any questions.
Seeing none? Thank you.
Thanks.
Mr. Lofton, I believe you have 3 minutes.
Thank you, Your Honors. I will try to come in just at 3 minutes or less. So I believe that this court will be forced to speculate in what it is doing due to the scant nature of the order that it has. I think it's a necessary conclusion, just a logical, conclusion that part of the reason that order is so scant also has to do with the COVID pandemic. It was like I said, 5 months into it is a time that everybody is trying desperately to forget because of the otherworldliness of it. Okay, so right, the order that this court has does not provide. It is slightly over 1 page. It does not provide a statement of facts, undisputed facts from which it bases its decision. It's not a simple lease. There were 2 affirmative defenses.
Is that necessary in light of the fact that the only evidence that the court had in front of it that it could consider was the statement of undisputed material facts submitted by the plaintiff in this matter?
Your Honor, I apologize because there is law to the effect that those affirmative defenses have to be, there has to be a statement one way or another as to the court's position on those affirmative defenses in that ruling. And I've looked at that issue before, but I apologize that I do not have the case that is on point. Those affirmative defenses, Your Honor, were that the underlying contract was procured through criminal fraud in the inducement, and it was void or voidable. The other was that the underlying contract was void as the consideration for the same does not exist. Now, bear in mind that the criminal wire fraud scheme involves serial number swapping with leased equipment.
But we don't know anything about any of that, do we?
And neither did the trial court, Your Honor, and neither did the trial court.
Mr. Lofton, how did you put that at issue? You didn't respond to the motion for summary judgment, did you?
Your Honor is correct, and that's to our detriment.
Well, let me also ask you, with this sort of equipment lease, what more should the trial court have said in its order other than you've got a lease, it wasn't paid, the property was sold, it brought a certain amount at the sale, this is the deficiency?
Thank you.
What more should the trial court have said?
Thank you for asking, Your Honor. I believe that it was required to, make some brief statement to the effect as to that regarding the defendant's affirmative defenses. The court rules that these are invalid for X, and just there is.
Now, you had a pleading that talked about affirmative defenses, but in connection with the motion itself, you didn't put that at issue because you didn't file anything, did you?
Your Honor is correct. There was not a response filed that re-raised that. It's our position that those affirmative defenses required some comment by the court in its final order, though.
Wouldn't the comment first have to be made by counsel and some pleading beyond the answer that was filed in connection with the motion for summary judgment?
That's correct, Your Honor. That's correct. To be accurate, but this all begs the question of whether or not the trial court had what it needed. I think that if there had been a setting order, the court could have said something to the effect that no further continuances will be granted. And that would have been the kind of thing that the trial court would have needed to have done, especially during the pandemic, to drive the point across that it was going to, do what it did here. So that's all I have, Your Honors. I appreciate the court's consideration.
Thank you. Thank you, counsel. We will endeavor to get an opinion on this matter to you as quickly as possible. We appreciate your argument. Thank you. Sanji, you may call the next case, please.